The cost of arguing a Ten Commandments case before the nation's highest court apparently has a pretty big price tag. And now the question, who pays for it all?
A federal judge says Pulaski and McCreary County governments must shell out nearly $400,000 in legal fees. But as Phil Pendleton reports, some say that bill may never be paid.
It's an argument that has lasted 10 years, and it all has to do with a Ten Commandments display that used to sit alongside historical documents in the Pulaski and McCreary County courthouses.
We haven't lost yet and don't intend to, because I believe that what the counties have done is totally in compliance with the law and is constitutional.
Christian radio host David Carr says despite the Supreme Court ruling the commandments displays in Somerset and Whitley City were unconstitutional, the counties never did anything wrong because he says they follow the lower court's orders. But now they're being ordered to pay almost $400,000 to the ACLU, the group that argued against the counties and ultimately won their argument with the Supreme Court in 2005.
I don't know if it's something to create a fear or what, because the case is up before the Sixth Circuit and there's nothing that can be done until after their ruling.
No one has received a bill yet because the case is on appeal. But the question is if taxpayers could be forced to fork over the money if the counties don't have enough insurance money to cover the cost. There is the argument and the belief that these counties should never have to pay these legal fees because the higher courts have already ruled that similar displays are legal and constitutional. In fact, the Supreme Court did not rule against a display at the Texas Capitol in Austin. And other Kentucky courthouses still have similar displays.
Well, I think the favor is for the counties because they have complied with the law.
The Sixth Circuit Court of Appeals could rule on the commandments issue later this year or early next year. In Pulaski County, Phil Pendleton, WKYT 27 News First.
In her ruling, Judge Jennifer Kaufman said the case consumed more than 1,000 hours of work hours over 10 years, led by an ACLU attorney.